Hey everybody, Attorney John Waite here, and I am coming to you guys today to bring you some updated forms and forms changes. Yes, I know it's only October. I understand. You just had forms changes in July, but you know what? You guys have been so busy and doing such a good job of making all the adjustments that you've had to make over the last couple months that we thought it'd be a good time to just throw another thing on there. No. I'm just kidding. I'm just kidding. No, these forms changes are very important, and they are coming out to meet consumer and member demand. And I'm going to cover a couple things about these forms changes real quick. In case you don't know, the best place to get the best information on forms changes and just generally what's going on is here at ncrealtors.org. You can go to the legal Q&As. And the summary of these forms changes and a Q&A about the forms changes will be coming out very soon. It'll be posted here. I'm posting this on Saturday, but the Realtor Rundown should come out Monday. And the Q&A will be located here on Monday, along with a summary of the forms changes and things I'm going through today. Okay? So I just wanted to point that out. Don't feel like you have to bookmark this video. I don't like listening to my own voice, so feel free to skip that and just go straight to the writing if you would prefer that. But if you do want to hear a recitation of some of the forms changes and what we got coming out, then you can stay on this video. All right, so we got 4 things we are going to cover in this video, and I'm not going to spend a lot of time on each one, but I am just going to give like a broad overview of the changes. Some of the changes are pretty substantial, some of them are more technical. So let's start with Form 201. This is the exclusive buyer agency agreement. It has been completely rewritten. Okay, so let's just scroll down through this thing real quick. Okay, here's page 1. All right, here's page 2 and page 3, and that is all in the signature lines. Okay, it is a 3-page exclusive buyer agency agreement. Here you can kind of do a little side by side. This is the old form. The old form is 7 pages long, and I just kind of want to go through a couple of the things in the new form 201 compared to the old one. Okay, first of all, functionally it operates very much the same. It just does. There's not a lot of difference between the old Form 201 and the new Form 201. You will see that certain things are missing, like notes and warning boxes. Some things that used to be long explanations are just short explanations now. And the reason for that is because the whole goal and the purpose behind the rewrite of new Form 201 is to just make it more user-friendly, make it user-friendly for members, user-friendly for consumers, but at the same time making sure that it functions the way that it is supposed to. And the way that it is supposed to, and I explain this all the time to agents when they call the NC Realtors hotline, is that a contract isn't going to stop anyone from doing anything. That's not what it's even designed to do. A contract is a written agreement between 2 people, and then if one of the parties wants to not do what they said they were going to do, then the writing gives you the ability to go to mediation, take that person to court, or maybe just show them in writing where they agreed to do something. Okay, in any event, a contract is not necessarily going to stop someone from doing something, but in the case of you guys and your clients, yeah, sure, most of the time things are just going to go through the way it's supposed to. And my experience with realtors is that you're going to do a good job, your client's going to be happy, and then we move on. But every once in a while you got a client who wants to not do what they said they were going to do. They hire you to do a service, and then they just for whatever reason they decide they want to breach that agreement. Okay, that's when the form is going to step in. Not only that, so that's just one purpose of the form, but the other thing is to inform the relationship. In other words, to set some ground rules about this is what we're going to do. And so when you guys sit down and you talk through with your client, that's one aspect of how you're going to go through and establish what kind of agency you're going to be providing, what kind of services you're going to be providing. But then there's also this element of, is the agreement itself, the contract itself, easy enough to understand? The goal of these changes is to help make that easier so that when your clients read something that they will understand it. Okay, Same thing with you guys. Maybe same thing with realtors. Just trying to make it all around sound less like a lawyer wrote it. Because honestly, we love to use too many words. It's just what we get paid by the word. No, I'm just kidding. We don't get paid by the word. But if we did, we would still write the same and write too much anyway. So I guess it wouldn't really matter. In any event, let's talk about this new Form 201s and just look at one specific thing. For example, here at the beginning, you've got a little preamble about what services are going to be provided. And there's an overlooked section in the current Form 201 that's right here. Firm may assign other agents in the firm to provide services at any time, agency services at any time. That's up here too. Some of you didn't even know that, did you? Don't worry, it's okay. It's a pretty common thing I have to explain to agents on the hotline that you can assign another agent. It's right here in the first paragraph. But it's things like that. There's a lot of things. If you go to the old Form 201, and you could pick out things from this, like compensation. Here's the current compensation section, right? Okay. Now you're talking here about a compensation section that is, about what? A page. It crosses over on another page, okay? And the way it works, and as I'm sure most of you know, is that your fee becomes earned, when the buyer goes under contract for a property, for example, and there are a couple other triggering mechanisms, but the fee becomes earned, correct? Then there's another paragraph here. It's about due and payable. There's also a protection period. Those are the main components of this particular section of the current Form 201, right? So we'll go over here to the new one. And here you'll see the same thing, except that it is taking up about a half a page. And that's pretty much the theme from the old Form 201 to the new Form 201. It is as far as how it works, it should work substantially the same. The clarity, though, of the language and hopefully the simplicity of the new language will help everyone understand a little bit easier instead of having to go through and chew through 7 pages of things like this. You have firm's duties right here in paragraph 6. Those are now up here, and it's just a sentence or two about things you're doing. It also explains that you're an exclusive agent and that everything needs to go through you. And that's really what we're getting to. If it was said in, let's say, 4 or 5 sentences in the old form, then the goal was to try and make it one sentence that's easier to read in the new form. Okay? There are certain things that are not going to exist in the new Form 201, and I'll just give you one example of that real quick. Here you have the term of the agreement. Okay? And it starts on the effective date and then it ends at a certain time, right? Here in the original 201, there was 2 different sections for that right here. One is what's in the new Form 201, but then there's also this extra checkbox where if the buyer was going to buy more than one property, then you could have it for a certain length of time. In the new Form 201, instead of relying on that sort of additional language, then what you can do instead, if something was removed like that you really liked in Form 201, you can add it back in by simply putting additional terms down here. There's a little sentence here that says if there's a conflict between the terms of this section and any other part of the new Form 201, then this section will control, including if you draft an addendum and attach it or something like that, then that will serve to help adjust this form the way that you want it to work, okay? All right, so that's kind of like the comparison of back and forth between old Form 201 and new Form 201 and kind of a little bit of the context and background. So now let's just go through new Form 201 and just look at what is in it. All right, so paragraph 1, as I said, we've got the services that are going to be performed, talks about how you are going to be an exclusive agent, that everything needs to go through you, the client needs to cooperate with you, firm can assign other agents as necessary to help the buyer, and that your firm may represent other buyers who may also be interested in the same properties as this buyer. Okay, paragraph 2, we have the buyer making some disclosures to you. The first one in A is, I think, a new thing a new, well, it might have been important before. It was required in the Code of Ethics before. But I think especially now, when a lot of buyers may well have multiple non-exclusive agency agreements with other firms, there's just the buyer making sure that they disclose, that they've signed other documents with other agents, so that to make an inquiry and figure out, did they actually sign an exclusive agency agreement with someone else or not? Maybe they didn't. Maybe it's a non-exclusive, or maybe it's an exclusive that has a limited territory. And while I probably should go circle back to paragraph 1 here. In the 2 lines in paragraph 1, you're going to identify the type and location of the property, and that is the scope of your agency. It's a very important section. It's important in the current Form 201. If you look over here, okay, type of property, general location, other. If you are only an exclusive agent for the territory that's put in there. A lot of times agents will ask me on the hotline, what should I put in there or whatever. And other agents will just put in the state of North Carolina, things like that. I encourage agents to make sure that you are filling that out as accurately as possible. If you're not truly shopping houses everywhere in North Carolina, or if you're not even competent to do that because you don't know the area or whatever, then just make sure that section's accurate. It may well be that your client is shopping all over the state, and that they want you to help no matter what market they are in, because you have a certain skill set that would accommodate that. Then that makes sense, sure. But if you truly are only shopping like a couple counties, and that's really all you're going to do, and that, make sure it's accurate, okay? And especially in this environment when it seems I've just seems like I've been getting calls, and maybe this will be more of a trend or not in the industry, I'm not sure. But with buyers having to be a lot more cognizant of how they are, funding agents and things like that, or how they're, paying for the services of the agent that they're using. You want to make sure that territory, or a lot of times it seems like buyers and buyer agents are scaling down the territory, whereas before maybe it was a little bit broader, just because the issue of compensation was not as important. Now that it is, it just seems like that is a way where the buyers and buyer agents are negotiating and slimming down the territory. So just make sure that when you look at paragraph 1 here, you're putting in the type and location. If you need to, attach an addendum to, because those lines don't accommodate that, then just go ahead and do that. That's perfectly fine. You can say something like see attached or anything of that nature. Okay. Anyway, skip it back down to 2B here. Okay, buyer is or is not working with a relocation company. This was something that was adopted in the form last year, and important information that you're going to want to know about simply because of how it affects the transaction. So that still is in here. And then the buyer makes a representation that they have or have not received sample copies of the purchase contract and the professional services disclosure form. So make sure you're giving your client, buyer-client sample copies of those, and checking the box there. All right. Term of the agreement, we covered that. Fee for services. Again, this is as far as comparing this form to the old form, it's very similar. You put down what goes in here. Now, mind you, there's a section here. This section here, this language here in the old form. This is in here, but the interesting thing is that, at least in my experience, buyer agents were not very good about filling this out the way that they're supposed to. It says very specifically, don't insert NA, put in a specific amount, things like that, okay? I feel like that has been improving and getting better with the new MLS rules, because the new MLS rules now also require that, but the license laws always required that. So if you weren't filling out a specific amount before, then you need to now, for sure. It's against MLS rules not to, and it's also could get you disciplined from the Real Estate Commission. So when you're filling out this section 4 at the beginning, you've got specific amounts here, and that you can put down. You can put a non-refundable retainer, depending on whatever you agreed to with your client. Just make sure it's specific. Now, if this amount changes, then you can use Form 710 to amend this agency agreement, Okay, so just understand that amending your agency agreement is there's still a form that accommodates that if you need to do it. Okay. And then in 4A, you have the fee earned and due and payable. That is substantially the same as the old agreement. Okay. In Part B here, we have a disclosure about how the buyer agent firm, selling firm, whatever you want to call it, they may seek compensation, cooperative compensation, but making it clear that the buyer owes the fee. I just had a discussion with somebody on the hotline about this yesterday, Friday, and it was a discussion where the agent really felt that the seller in that particular transaction just didn't do the paperwork correctly to make sure that funds that were supposed to be a credit from the seller to the buyer were used to pay the agent's fee, and it ended up that at the closing table the agent did not get paid. And I had to explain to the agent, listen, that's all fine and dandy, but you don't have a contract with the seller in your instance that obligates them to pay anything. Like your client is the one who hired you. Your client is the one who owes the fee. And that is something that is going to be an important fact, just to make sure that agents understand better and better. If you are a big of a firm, just make sure your agents understand that and understand that it's not, unless the seller has taken on that obligation somehow, then it's simply not their obligation. And that's true here in paragraph B. It makes it very clear to the buyer that while cooperative compensation may be a factor in the transaction, the buyer ultimately needs to pay. Okay? Paragraph 4C, this was a change that was made intentionally in old Form 201. And if you have any, as you phase out these old agency agreements, just understand this is something you're going to have to check if you do have a dispute with a client. But down here toward the bottom, right, there's this part here that talks about termination, breach, attorney's fees, things like that, right? One of the things was mediation in the old form. And if you want to mediate with your client, you certainly can. But in my experience, a lot of times when agents were having a dispute with a client, and then they would, sometimes they would come to me after they tried to take them to small claims court or something like that. They had skipped the mediation part here. And what will happen is if you don't do mediation, or at least demand it first, then what will happen is the court will kick out your case. Like you won't be able to, get it. Judgment against your client if they refuse to pay, if you haven't tried to do mediation first. Another thing that you got to be careful of, and that's true for old forms and new forms on as far as 2-1 goes, is that the firm is the party who has the contract with the client. If you look at the top here, these two lines here, these are going to function the same as the current form, where the agreement is going to be between the buyer and the firm. Sorry, I got to move my little window there so you can see that. But yeah, buyer and firm, right? And it's the same thing in the old version of the form also. So make sure that if you're an agent and you're having an issue with a client, your client's being unfair or whatever, they've breached the agency agreement. Your firm is really the party in interest, and so you probably cannot bring a case in your own personal name if you're the agent. Okay. Anyway, moving on down, back to 4C here. So instead of requiring mediation like the old Form 201 did, you can certainly do mediation if you like, but it is purely voluntary. And I know most of the time, by the time mediation was demanded, at least in the cases that I worked on, there'd already been a lot of talk back and forth trying to work it out ahead of time anyway. Nobody really wants to end up in court if they don't have to. I haven't had a single client that's, taken anybody to court and said, well, that was a lot of fun, let's do that again. It does not happen. So I think that's still substantially the same. So just removing the official mediation requirement just makes it easier. It's less of a trap, for especially for small firms and brokers who may not be able to. They want to use small claims because they need to use small claims, and because the fee's just not big enough to justify lawyer expense to go try to get paid. In any event. 4C here makes it clear that in order to terminate this, there has to be mutual termination. This is also a change from the old agreement where there was some language here about, here we go. This language here, I've gotten questions about this language on the hotline over the years. It's just a little bit too confusing even for agents to understand. So it's been simplified over here to just make it clear that, you can, a buyer can tell you to buzz off. They can hire another firm at any time, but it's not going to change the fact that they are going to owe potentially 2 fees to 2 different agents if they buy a property. So 4C is meant to just make that clear, make it simple, and then make it easy to understand for the client that they're hiring you to be an exclusive agent, and you are taking on significant risk by helping them. There's a lot of times where you guys will be out there hustling for a long time with a buyer before they get under contract and potentially make a purchase, if they ever do. So you're taking on a lot of risk by doing that, and that's really what this is meant to do, is to give you that protection for making that involvement, and honestly spending that time and expense on a client who then turns around and buys a property without consulting you first. Okay. All right. Paragraph 4D, we still have the protection period. So this is going to function substantially the same. And, just like in the old form, the protection period is going to get cut off if the buyer, hires a new firm. So just understand that. It works the same as the old form. All right. Moving on to paragraph 5, buyer understands, negotiable fee, and that additional compensation, if there is any, the buyer has to specifically agree to it in another agreement. Like I said, Form 710 can be used to accommodate those scenarios. This language is required by the settlement, so that survived the old form is in the new form. In the new dual agency section, I know it's a lot shorter, but it is substantially the same. And especially this section here, where it talks about the relationship and how it may change if there is dual agency. Okay, it's really just to clean up from the old form. As far as the actual rights and duties and things like that, those are all the same. You can compare and go back and forth between this section in particular. So it's paragraph 14 moving on down to between pages 4 and 5 in the old form. But if you go through those, you can see the rights and duties are substantially the same. And I did try, to make, when I did the draft here, to make this initial section a little bit easier to navigate and understand. Hopefully it is, but let me go through it anyway, because it can be kind of a tricky thing. The first thing is, if the buyer client is going to authorize dual agency, then they're going to initial those first lines. Okay, so that's up here, right here, at this section right here. That's where they would initial if they're going to allow dual agency. All right, so then the next question is, all right, if there is dual agency, then is the buyer going to authorize the same agent to represent both the buyer and the seller? Okay, so that's the first question. Second question is, does the buyer direct firm to practice designated dual agency? If they initial this last line here, then they're not going to initial this line here. Okay, that's just not going to be a thing, because designated dual agency requires 2 different agents with a firewall between them to represent both the buyer and the seller. So, just hopefully that's a little bit easier than, the current Form 201, where you're down here, it's got check boxes and then a designated line and then exclusive representation. Here, with the new Form 201, hopefully that's a little bit easier to follow. It's a very slight difference, but again, how it works is substantially the same. All right. And then here you got a disclosure about material facts, regardless of dual agency, that's going to exist. And then finally a waiver, a limited waiver just for dual agency. All right, here we have another, this is again a holdover from the old form, and I think it's, where is it? Yeah, here. So these paragraphs here have just been boiled into one shorter, easier paragraph, but really warning the client, hey, don't be snooping around the house taking pictures, okay? Don't do that. That's an easy way to get in trouble. So make sure that is that. Also giving a warning about the fact that there could potentially be surveillance and things of that nature on property. Now, paragraph 8, we got other professional advice. Your buyer client can get other professional advice on other things, including have an attorney review this agency agreement if you like, and also making it clear that the buyer needs to pay for these things in paragraph 9. All right, and anything else that may go along with inspections and things like that with a property. Paragraph 10. This is a required disclosure. Firm will not disclose the price or other terms of a buyer's offer to a competing party without the express consent. So there you got license law. But then in the second part, you've got a sentence there about how, warning the buyer that a seller is not an agent. So they may not keep the buyer's offer confidential, and they might also not tell a buyer about other agents' offers, other buyers' offers. So making sure that's in there. That's a disclosure from the Code of Ethics and from the license law. So keeping that in paragraph 10. The wire fraud warning here is substantially the same as the old one, and that'll be in really the biggest thing is taking that language and instead of having it be all capital letters and something that might not be easy to read, giving it a highlight with just red text so that people know that, hey, this is important. It's the only thing in red in the entire agreement, okay? And then, and then making it easy to read by keeping the font just simple. But make sure you go through that with your client and give them a wire fraud warning. We talked about paragraph 12 and additional terms. This is a section that may get used more often now. If your firm has a certain way it likes things done, certain things that may not be in here, then feel free to have a custom addendum, attach it, and that'll adjust this however you need it to. Okay. Here we have some, it's lawyerese, but hopefully easy to read lawyerese. Just making sure that the document is the entire document, governing law, attorney's fees, things like that. And then finally we have the non-discrimination, which is a mixture of license law as well as Code of Ethics. All right, and then we got signatures, and that's it. So if you go through the old form 201, you can see, we got type of property, effect, we got compensation, we got other potential buyers, firm's duties. Those are in the first paragraph. They're just not as broad, a little bit more general, but that's okay. We got confidentiality, which standard of care. Those are all things that are implied by the license law. They don't need to be explicit. Feel free to cover them with your client, of course, but as far as whether it needs to be in the form, it doesn't need to be in there. But of course, if you want to attach an addendum to the new Form 201 to make those things explicit, you certainly can. Same thing with buyer duties, condensing them all into essentially the first paragraph, where making it clear that they just have to cooperate with you and facilitate everything through you. Okay. The home warranty paragraph, again, if you want to add that, you certainly can. You have to disclose, especially if you're getting paid anything, you have to disclose that to your client anyway. And now under the new rules, your buyer client's going to have to specifically agree to it. So that's something that's better handled through an amendment anyway. Therefore, it didn't need to be put into the new Form 201. Confidentiality, we covered that. That's in the new form. We got dual agency in the new form. There it is in the old form. And then we've got these sorts of like lawyer boilerplate to make sure the form works the way that it's supposed to. And those are captured here along with the wire fraud warning. So hopefully that shows you how, yes, we went from 7 pages down to 3. Hopefully it's easier to read and should function very much the same. One important note about this particular forms change to Form 201 is that it'll be a 30-day grace period instead of a 60-day grace period. So to make sure that as soon as this is released, which should be in the next day or two, that you start using it as soon as possible and start using it with your new buyers. Your new buyers will appreciate it in any event. All right. The next thing that we got that's been adopted is we have a 1-page property showing agreement. And so a lot of people are call them touring agreements, showing agreements, whatever you want to call them. What they are and what they have to be under North Carolina law is they need to be an agency agreement, and they can be exclusive or non-exclusive, however you want to do them. Okay, this particular property showing agreement, which has been approved, newly approved by NC Realtors, is a non-exclusive. Okay, so that means that a buyer could go out and have a dozen of these or 2 dozen of these with different agents. Okay, but if you look at paragraph 1, the services provided is very limited. So you're just showing houses. That's what you have the scope of authority to do. You don't have authority to make an offer. So and it makes clear in the first paragraph that you may need to, the buyer may need to agree. They don't have to, but they may need to. The firm may ask that they sign another agency agreement before they make an offer. Okay. Other showing agreements, just making a disclosure here. Term of agreement, same thing. It can expire for a day, or you could have it go on for a while, however you want to do that. In paragraph 4 here, you have to. If there is going to be a fee between you and a buyer, then it must be specific and it must be agreed to in writing. Okay, and that's what paragraph 4 is. But there's also a checkbox there for no fee. So if you don't want to charge a fee to your buyer, that's perfectly fine. And then finally, paragraphs 5 and 6, we got negotiability, non-discrimination, and then signatures. So hopefully very simple. Hopefully, something that will be easy for you to navigate. Moving on. We got some changes to Form 220. A lot of them are just technical and meant to sort of line up with the next form I'm going to show you, with just the new guidelines to Form 220. Okay, but the biggest change is actually right here in the middle. So this section right here, and it's just to make it clear that if a listing firm ends up not being paid because of a seller breach, that they don't need to pay the selling firm. I think that's probably already technically true, but under the old Form 220s, however, just to make sure that it's clear, you don't want to end up not having that work in your favor. So I do recommend that if you have old Form 220s out there, then you're probably going to want to consider updating to the newest form here, just to make sure, on the off chance that the seller breaches, that you won't be on the hook as a listing firm. Again, I think that if the old Form 220 ended up in court, the listing firm, in that scenario where the seller has breached, this listing firm agreed to pay cooperative compensation, the buyer, buyer agent or selling firm wants to get paid anyway, the listing firm is going to have quite a few defenses to raise in order to say, hey, it's not fair to make us pay when our seller, our client breached and we didn't even get paid. Okay, so I think that technically, the old Form 220s, they should, come to the right result. However, I think that I think that the Forms Committee rightly decided that there's value in making sure that this is clear. So that's the biggest change. Otherwise, the new Form 220s, that are being revised and being released, right now, they're 1 page instead of 2 pages. So that's kind of where it started, and then the guidelines, and then as long as we're working on the form. Forms Committee decided to make that edit too, so hopefully avoid a bad situation. And then we have new Form 220G, which is the guidelines to Form 220. All right. Now, these guidelines are a lot different than other guidelines we have currently in the library. These guidelines are really kind of all around how you use the form, instead of going line by line and saying, this is what this paragraph says, this is what you fill in the blank, blah, blah, blah. These guidelines focus more on, this is how this form may move and navigate. Okay, so here you have, you start here in the corner, and just, has the seller authorized cooperative compensation or not? Yes or no. Is it a blanket offer? Meaning, is it like made to everybody, no matter what, or is it something where the amount of cooperative compensation might vary depending on what the buyer's offer is? So going through those scenarios and who needs to sign based on those scenarios. So hopefully, this has obviously been a source of a lot of hotline calls, but it seems like fewer hotline calls now. Let's see, today is October, 19th? Yeah. Fewer calls now than we were getting, say, a month or two ago. But in any event, there's still some calls on that, and besides, when you get new agents in, this will be a handy tool for them to figure out, okay, well, how does this need to move? Then on the second page of the new 220G, we have 9 just pieces of information. For example, don't attach 220 to a purchase contract or put it in the MLS, things like that, and just making sure that's clear. Finally, so this is the summary. Every time forms changes come out, there's a summary that's posted. It's put in the legal Q&As, as I mentioned earlier. This is a copy of what will go in there, and what's in here is interim guidelines for new Form 201. So if you want more detail about how some of these sections work and some of the things you could do, sort of how you could navigate, a lot of the things that were in the old Form 201 guidelines is still good information, still good guidance. So a lot of that was brought over into these interim guidelines. You can see these interim guidelines are very, very detailed. They go into more detail than what I've even gone through today. Make sure you look at these guidelines. If you need help, further help on how to navigate the new Form 201 exclusive buyer agency agreement. You can also see here there's a couple little blurbs about the new forms also. So that's what I've got for you guys, and hopefully this has been a helpful little tutorial on the new forms, new forms changes coming out. Stay tuned as we go through this entire year. It's going to continue to be a busy year for forms changes, and maybe even forms changes released before July next year. All of them with an eye on just helping make sure you guys have the tools you need to navigate. So you focus on doing your jobs, and then if something goes wrong, then the forms are there to hopefully help you. All right, take care.